Hi, fellow Toolboxers. Welcome to episode 269 of the Immigration Lawyers Toolbox podcast. We're having a great one, another one with Kevin A. Gregg of the Kurzban, Tetzeli, and Pratt Law Firm. He's a partner there in San Diego, and he's got the great podcast called Immigration Review, where he goes into federal court cases, and we do this every month, where he comes and talks about the juiciest cases that I want to talk about. And so I have a great time doing it. And he's a great friend. I'm going to be on his podcast probably in a couple weeks, and hopefully get that out so you see a different angle. He's gonna be questioning me on this stuff about just everything he wants. So definitely check that out. The conference is coming fast in February. We're organizing it. It's going to be really fun and really informational, educational. If you want to expand your firm and teach your associates or learn a new area yourself, particular O1 visas, repeat visas, repeat business, great for recessions. That's what you want. That kind of practice. Come and join us. Got the best immigration lawyers that do O1s in Los Angeles coming. It's really something to see. Plus, it's a one-on-one in-person networking. We're keeping it very small intentionally so that there's relationships developed, not just a come and go kind of thing where we forget about each other. I don't like that kind of stuff. So it'd be great to check that out. Just email me at info@immigrationlawyerstoolbox.com for information about that. We have other courses. We have the marriage immigration course that goes over consular processing and admissibility. And for those who are getting into immigration, it's really the best thing you can do is get this course and have a jump start so you can start your practice. Check that out. And the magazine's just wonderful. Colleagues give so much content. New issue is supposed to be out any day now. But go to immigrationlawyerstoolbox.com, click on the magazine tab and check out old issues. And not old, everything is new, because I try to get evergreen kind of content in there so it could help you out. I do want to thank our sponsor, DocuWise. DocuWise.com has been so helpful. They just added a new feature in their software, which is getting your forms e-signed. So I use one of these software. I think use HelloSign or something like that. But they're taking business for HelloSign because it's an all-in-one package right there. So check it out. You get 10% off your annual plan by go to DocuWise.com/immigration-lawyers-podcast. And definitely check it out. Give it a try. It's good software. We use it, so I think you'll have a good time with it as well. Having said that, it's all general education only, not intended for individual legal advice. Please, talk with their lawyer, although people listening to this probably are lawyers. So having said that, let's get it started. Hey, Kevin, thanks for coming on the show today. Again, it's November 1st, and we're going to go over things that happened in October. There was a couple of court cases, one or two in particular, that were really like big deals. And I'm sure we haven't gone through what we're going to talk about. I'm sure you're going to talk about I think it was the Ninth Circuit did something. I kind of completely lost memory, but let's see if you're talking about it or not. So how should we start?
That's right, John. Good to see you again. Good to be back as always. Love coming on your show. I think you must be talking about Muñoz v. Department of State. Which,
exactly. Where they called into question consular nonreviewability or something like that.
Called into question is to say it lightly. They blew it up in a very narrow circumstance. And I said it on my podcast that my tweet on this case went viral. My wife was very quick to say that you're not viral if you only get 100 likes, but I think it's viral.
100 likes, that's huge for immigration, yeah.
I think I went viral on Twitter, Elon Musk's Twitter. Muñoz v. Department of State. I mean, it's outrageously complicated. The Doctrine of Consular Nonreviewability essentially says that the Department of State can deny visas no matter what without even really explaining themselves, and that's on Kerry v. Din and all of those cases. Muñoz v. Department of State, before I get to the holding, though, it has a lot of interesting stuff in it. First of all, the Ninth Circuit is relying on concurrences from Justice Kennedy. The only reason you can even get in the door, it's possible that Mr. Muñoz, who's a non-citizen abroad, doesn't even have standing to challenge it. It's possible. But Miss Muñoz, his wife, a U.S. citizen, does. And it's interesting, man. It's based primarily on Justice Kennedy, who's no longer there, the fundamental right to marriage, and there's a fundamental right to live with one's spouse, or at least a constitutionally protected one. And so those two fundamental rights, according to the Ninth Circuit and Justice Kennedy, are in tension. That fundamental right to marry from Obergefell, the same-sex marriage cases. And so, as an aside, if the Obergefell line of cases falls after the abortion stuff and the current Supreme Court wanting to blow up Justice Kennedy's legacy on fundamental rights, then we have a very possible different consular non-reviewability jurisprudence. Maybe you can't sue at all because there is no constitutional rights, but as I did in my podcast, I digress. Currently, there is a fundamental right to marriage and to live with your spouse. And so how do you infringe on that? And with the doctrine of consular non-reviewability, one of the main ways to get around the doctrine is to show bad faith. That's one of the main, and it's almost impossible, right? Because you've got a consulate officer abroad, and how do you show what? Like that the consulate officer is racist, that they just don't like you because you used to date their brother? I mean, God knows what is bad faith, how do you even show it? And you need discovery, but the doctrine of consular non-reviewability blocks discovery in federal court too. I mean, the whole thing is crazy. And so this case says, if the Department of State doesn't timely tell you why they're denying the visa, then the doctrine doesn't apply, even if they tell you later. What is timely? I don't know. But like in this case, the Department of State kept letting it seep out over many months and eventually years after federal lawsuit, that eventually they made it very clear Mr. Muñoz's tattoos, and some Department of State guy from El Salvador or some contractor said he's MS-13. Like that all came out eventually, but it wasn't timely. And so even though it came out eventually, the doctrine didn't apply. And if the doctrine didn't apply, well, you've just got a regular federal lawsuit against the Department of State, where it might be before a federal judge whether or not it was appropriate for them to find him MS-13. Now, there's a lot of qualifications. The ground of inadmissibility they were alleging he fell under was just the general criminal conduct one, and that one might have additional requirements. So it does get a bit, it is a bit specific, but it is it's a big chunk into the consular non-reviewability doctrine. The counter is that all they have to do is provide basic notice of the reasons they're denying in the future, and they get around this decision. Plus the ninth might go en banc, but we have so little to challenge the consular non-reviewability doctrine that something like this becomes a big deal.
But just getting them to give that from the DOS standpoint is a lot, because from the case I've seen, I never had a denied case myself, but what I've seen, they don't tell you anything. Just send the case back. And you're emailing them, they're like, "Well, we sent the case back." And I'm like, "Well, why?" Then you wait
for revoking the I-130?
Yeah, revoking I-130. Yeah. So this will force them to do something, but then again, they could probably just say, "We didn't believe it's real." And then what are you going to do? How specific do they need to be in their explanation? But at least it's something.
Yeah, I mean, that you're taking the counter, rightfully so, the counter argument that many people in the Twitter feed then took, like, oh, they don't have to do anything. Oh, they can just go en banc in the Ninth Circuit. Maybe so, but I mean, look, like when you're drowning, you take the worst life raft you can get, right?
Yeah.
I mean, there is nothing. We had nothing for consular non-reviewability. Now you have something in the ninth, and that's what we do, right? How far does this decision go? How much notice is proper? Right now, we've got a decision. I know that there are advocates who reached out to me after, who are in federal court all the time, who are already asserting this. So there will be mini Muñoz's going forward.
Yeah.
And we'll see what happens with the case, but it's a fun case. It's an interesting case. It's good stuff.
Yeah, I mean, this is really positive. At least, just chip at this non-reviewability stuff's really important, because it's just out of control. Cool. I'm glad I didn't read the case. I just read the headlines, so I'm glad to get some more info on it. What's next? So I want to take a quick pause from what we're talking about right now to talk about the Immigration Evaluation Directory.com, a wonderful place to get connected with the best resources, the best therapists to help you with your immigration cases. Did you know research reports psychological evaluations can increase an asylum application's chance of approval by 78%? Psychological evaluations are hugely beneficial in hardship cases and cancellation, asylum, and other types of cases with USCIS or the Immigration Court. Connecting with a qualified clinician has never been easier thanks to the Immigration Evaluation Directory.com. Free to use, you can filter the directory by location, language, case step, and much more. Then review profiles and reach out to those therapists for guidance and connecting with your client to do the evaluations that are necessary. The Immigration Evaluation Directory is your one-stop resource to find the best therapists to help. Explore more today at immigrationevaluationdirectory.com.
Well, yeah, stick with the ninth, and I know we only have limited time today, and so I kind of like doing the rapid fire. The Singh v. Garland case, the deficient NTA in absentia removal order case from the Ninth Circuit, pretty much the seminal case now that the Fifth Circuit has been chalking back its Rodriguez decision. Singh v. Garland barely survived an en banc challenge, which really just goes to show how important elections are, because had the Trump administration got a second term and appointed more Ninth Circuit judges, I mean, really, it was like a one-judge difference whether or not they would take Singh en banc. So as I read Singh and the law in the Ninth Circuit, and as Judge Collins reads Singh in dissent from rehearing en banc, quote, I'll just quote Judge Collins in dissent. The Singh decision, quote, casts doubt on the validity of potentially tens of thousands of in absentia removal orders issued in the Ninth Circuit over the last 2 decades. Judge, end quote. That's Judge Collins, not me. I happen to agree with Judge Collins, but I mean, if you have an in absentia removal order issued in the Ninth Circuit and to a lesser extent the Fifth Circuit, and it did not have the date, time, or location of the first hearing, and they were then ordered in absentia, removed in absentia because they didn't show up in the Ninth Circuit, I mean, you've got a motion to reopen right there. In the Fifth, a little bit more difficult, but you've got it there too. And and to me, that's a no-notice motion to reopen, and there are no time limits to a no-notice motion to reopen in an absentia order of removal. Tens of thousands of removal orders in the Ninth just survived in Bonk. Get them in while they're hot, because I'd be astonished if the matter doesn't go to the Supreme Court within the next 2 years. Obviously, all of this is because of Chavez and Pereira. There is a circuit split. The 11th Circuit has held opposite now in DaCosta Gomez, and the Fifth Circuit is just being weird. So I don't see how the Supreme Court doesn't do something, but you got at least a year before the Supreme Court does whatever the Supreme Court is going to do.
Should everyone who has immigration issues move to the Ninth Circuit? Is that the solution to a lot of these?
Hey, look, the Fifth was first. I don't like that. Look, there is great case law in the Ninth, but honestly, like for asylum, the Fourth Circuit, I think, has better case law. And, I mean, the Fifth was, hey, I'm not going to answer that question, but the Fifth Circuit was first on the in absentia removal order in Rodriguez, and that survived its own en banc challenge. So, like, honestly, this is statutory interpretation. In Rodriguez, some of the judges just can't stomach what the plain text says, and so they've been chopping away at it. But, like, I don't know. In this specific instance, it seems like the text says what it says, and especially in light of Chavez.
It's surprising the Fifth Circuit, I'm looking at the map, Texas, Louisiana, Mississippi, so it's a surprising
historically place. The worst, but with Rodriguez plus Singh, the most favorable case law in absentia motions to reopen is in all of the border states. I'd say, I don't know the statistic, at least 75% of in absentia removal orders, I would think, since 97 occurred in the Fifth or Ninth Circuit. I would think. I don't know.
Yeah, I mean, that's it. Arizona, Texas, all that kind of stuff. Yeah.
Arizona, Texas, New Mexico, California. Yeah. It's literally every southern border state. So it's
interesting.
Fun times.
You never know what to expect when it comes to courts, and when it comes to litigation, you always tell clients, and immigration obviously, but a lot of other areas, you never know when it goes to court what's going to happen. That's why people settle so much in criminal law and civil litigation, all that kind of stuff. You never know what you're going to get.
It's even worse though than that, because it's like, immigration judges sometimes roll your eyes when you're making these unique legal arguments in immigration court, but like so much of the current stuff with the deficient NTAs, it's getting like knocked down because the attorney didn't bring it up in 2004 when all of the case law was against the attorney, and they would have had no reason to bring it up. There's no case law, but then they're like, well, you didn't timely assert it, even though it would have been denied. I mean, you have to make these unique arguments and then see what happens.
Yeah, later. Stuff just to throw in there, like a prefab list in your motion to just say everything, just do it. Right. Yeah, ALEC should do a goodie list of stuff just to include in the motions, because you never know.
Yeah, it's unfortunate. Right? If you're an immigration judge, it's like, what are we even doing? Like, how do you adjudicate something not even knowing what the case law is going to be? I sympathize with immigration judges who want counsel to concede that their client has an aggravated felony when there is literally a Ninth Circuit case on point that says it's an aggravated felony. But like, if you concede it and then the law changes in 5 years.
And you run the risk of annoying the judge. Like, why are you making these claims when it's so preposterous? But like, I don't know what's going to be happening in 10 years. What do you want me to do? Yeah.
I think the Chavez and the deficient NTA cases are a case in point that the judges would have to understand, because every circuit has a case now that says this wasn't asserted below 10 years ago, so you can't bring it now.
Wow. This is such a peculiar area. It's so weird.
It's the best. It's the best. It's so weird and unique. It's the best.
Do we have a third case lined up?
Yeah, I'll be very quick because there's just two back-to-back First Circuit cases were issued 10 days ago. It's Chavez v. Garland and HH v. Garland, both litigated by ACLU, I believe New Hampshire. my friend Singh Kim, doing great work over there with the University of Maine and actually the University of another San Diego Law School as well. Just everybody coming to play on these First Circuit cases. And just to summarize what essentially happened in Chavez v. Garland, the First Circuit is essentially saying, even if gang members is not a valid particular social group for these, countries, there's a board decision from 10 years ago that says it's not. I don't know if that board decision was really good law anymore. Might be in the First Circuit, though. But even if that's the case, that being a gang member that's not a particular social group, imputed gang members is a particular social group. That is mistaken belief that you're a gang member, or maybe former gang members.
Yeah.
Right? Because maybe you've got some tattoos, maybe you hang with the wrong crowd, but if that could be a particular social group. And first of all, that's a big decision because it's not settled law that imputed particular social group membership can be a thing. I mean, there's imputed political opinion. That is, based on how you act, they think that you're opposed to the prime minister. That's imputed political opinion has been around forever. But imputed particular social group, you're not in the group, but people think you are. Unclear whether that can get you asylum. Mm-hmm. First Circuit is saying it can. And if they think you're a gang member, that also could get you asylum. So that's a big deal.
Yeah, that's interesting.
And in HHV Garland, there was some good case law on willful blindness for Convention Against Torture Protection. Not going to get into it now.
Yeah. It's
wonky. Listen to the Immigration Review podcast if you're interested. But I wanted to bring HH up because at the end of it, as I say on the podcast, the court is giving some real serious consideration of what asylum attorneys have been advocating for a long time, and that is, if you haven't, usually to get torture protection, you have to fear the state, the government itself, right? You have to fear the Salvadoran state, or you have to fear private actors, gangs, who the Salvadoran government acquiesces to. It's a high standard. But for a long time now, people have been saying, look, MS-13 is the government in lots of El Salvador.
Yeah.
There is no government. They take taxes.
They
give land. They do all these things. They're the government. So you don't need to show that the Salvadoran government acquiesces to their harm. They are the government. If they harm you, it's cat protection. Mm-hmm. No court has ever bought that argument as I understand it. But in HHV Garland, the First Circuit is giving it heavy consideration in dicta, but also giving a 3-step framework based on the 14th Amendment about when a non-state actor can be considered a state actor. That is, they assume traditional public functions. They become so intertwined with the government. It's a 3-step process. And, as lawyers, you get a 3-step process, you get a standard to apply, and we're off to the races. HHV Garland, the court gave us a standard to apply to argue that the non-government torturers are the government. And it's dicta, but it's good dicta, and it's something to look at.
Very interesting. Well, thank you for sharing those. When you mentioned the university, I just thought, are you going to be teaching that in San Diego Law School or something? It is in the plans. It's a lot of work. I know you got your hands full, but
I mean, you honor me with such a question. It is, it would follow a long tradition at the Kurzban Law Firm of doing so, and I personally would be quite interested in it. But I can't imagine adding something else to my plate at the moment. And also, I don't think there's a need in San Diego either. I know most of the adjunct immigration professors in San Diego. They're all excellent, but who knows what the future holds.
Sure. Well, let me know if I can help in any way. Thanks for coming on the show again. Hope everything's going well with you, and we'll go a little longer next time, catch up. And
that's right. Thank you, John. Great to see you, and on to your next interview.
Yeah, appreciate it. And, catch the Immigration Review podcast, wherever podcasts can be found. We're neck and neck in the top position. So
we're neck and neck, but it's friendly competition. And as you know, we're doing an interview of you on my show this month. So
we're going to.
It's in the Outlook calendar. We're doing it. If it's in the calendar, it's going on.
I might wear a bow tie or something, like clean it up.
I don't do video, so you can
wear nothing. Video. I just talk very radio like, maybe my voice thick or something. Thanks a lot, Kevin. I'll talk soon.
Bye, John.
Bye-bye.